All right, ladies and gentlemen, is there anybody who did not follow the instructions of the court? 16 minutes, not 15 or 10. There you go. Counsel, please proceed.
Thank you, Judge. Good afternoon. 8 days ago, my partner, Attorney Zahawi, he stood before you during jury selection and told you what his fears were about this case. He told you what his initial reaction was to reading the initial report, the complaint, that Crystal's remains were found on the Rasch property. That his fear was that jurors in this case would hear those facts and that they would immediately jump to the conclusion that Zachariah must have murdered her. Several of you in particular said that although that would also have been your initial reaction, that you would still want to hear more and see more of the evidence in this case before you could reach a conclusion. The reason that you all are sitting on this jury panel is because we expect that each of you has not prejudged Mr. Rasch and will fairly and deliberately consider the evidence that was presented in this trial. You took an oath as a juror at the beginning of this case to try the issues submitted to you, and unless discharged by this court, to give a verdict according to the law and the evidence given in this case. The law and the evidence. Let's talk about the law first. Mr. Rasch has been charged with 2 offenses. First-degree intentional homicide is count 1. That requires that the state prove beyond a reasonable doubt 2 elements of that offense. 1, that Zachariah Rasch caused the death of Crystal Rasch, and second, that Zachariah Rasch acted with the intent to kill Crystal Rasch. This entire case, in terms of the homicide charge, boils down to intent to kill. And did the state prove beyond a reasonable doubt that Zachariah intended to cause Crystal's death on June 11th, 2024? It is the most serious crime that exists under Wisconsin law. The second charge is mutilating a corpse. That offense also has 2 elements that the state has to prove beyond a reasonable doubt as to each element. 1 is that Zachariah Rasch mutilated a corpse, and second is that Zachariah Rasch mutilated a corpse with the intent to conceal any crime. That requires that Zachariah Rasch acted with the purpose to conceal any crime, avoid apprehension, prosecution, or conviction of any crime, not just avoiding prosecution for a homicide, but any crime. These are the 2 crimes that you have to determine whether the state proved their case beyond a reasonable doubt. What you know from the very first day of trial is that Zachariah Rasch is presumed innocent. He started this trial with a presumption of innocence, and it carries forward through even to today, even to this minute. Only if you, as the jurors in this case, go back to deliberate and reach a unanimous verdict of guilty on either count does that presumption of innocence disappear. The burden of proof in this case is high, as it should be. In criminal cases, the state is required to prove each and every element of every offense with proof beyond a reasonable doubt. That burden of proof is higher in criminal cases than in any other type of case. If this were a civil matter, the burden of proof would be preponderance of the evidence. If this were even a TPR trial, it would be clear and convincing evidence. But in this criminal trial, it is proof beyond a reasonable doubt. In jury selection, Attorney Zahawi asked questions of the panel about how people make decisions. What kind of information somebody might need if they wanted to purchase shoes, or an appliance, or a house. You can think of each of those as representing different standards of proof, different amounts of information that you need to make a decision. The bigger the purchase, the more proof you would need to make that decision. The decision that you make today, in this case, will be the biggest decision that any of you will ever make in terms of the impact that it will have on the life of a stranger. Proof beyond a reasonable doubt is the highest burden of proof in the law because criminal cases bring the highest stakes. The potential loss of someone's liberty. Let's talk about the evidence that was presented in this case. I think we can all agree that the vast majority of the evidence that was presented in this case related to things and acts that occurred after June 11th. During the opening statements, Attorney Zahawi asked you to keep 3 questions in mind as you listened to the evidence in this case. First, what element of what offense does the evidence tend to prove or disprove? Second, can the prosecution rule out that this was an accident or a suicide? And third, are you left with any lingering questions, any unsolved questions after the case was presented to you in full? The state's strategy in this case appears to be to overwhelm you with evidence regarding what happened after June 11th. We've seen the great efforts that they have made to introduce the same evidence many times and in many ways. For example, the bank records were introduced. Then they presented images and videos from the various locations where purchases were made. Then they presented to you the flock camera photos showing Mr. Rasch's vehicle traveling to these destinations. Then they presented you with cell tower tracking maps. All of this is just compounding evidence that shows the same point. The bank records on their own and a handful of pictures would have been sufficient, but we all sat through hour after hour of this kind of presentation. The same applies to the remains that were recovered, pictures of the excavation site, dozens upon dozens of photographs, and then testimony from the various experts to then re-show a lot of those same images over and over again. For example, with Dr. Karsten, bone fragment by bone fragment, each and every individual fragment was shown to you. The same goes for the Google searches. Pictures of the searches and then accompanied by images of screenshots taken from the Cellbrite report and on. Day after day, the prosecution has labored on in a tedious and repetitive manner. But despite their efforts to flood you with this information, they did very little to investigate the days, weeks, and months that led up to June 11th. There was almost no evidence presented about what happened inside of that Mitsubishi on the drive back from Milwaukee on June 11th. That's the critical question that needs to be answered by you in this case. And instead of conducting an investigation that examined the days and the weeks leading up to June 11th, this investigation that was conducted presumed that a murder had occurred and really only sought to find evidence to support that initial conclusion. Whether you call it jumping to a conclusion, confirmation bias, or tunnel vision, law enforcement in this case assumed from the very beginning that Zachariah was responsible for Crystal's death, and they did not investigate that there could have been an alternative reason for her passing. In the words of Detective Contney, verbatim, he sat on that witness stand and he told you, "I think we can all put 2 and 2 together." He reached that conclusion from day one of being assigned to this case and the course of the investigation that followed that assumption. He did precisely what we are asking you as jurors in this case not to do. Over the course of this trial, you heard from 21 different witnesses, 20 from the state, and finally from Mr. Rasch himself this morning. But how many of them had relevant evidence, relevant testimony to provide regarding the intent element of count one, the first-degree intentional homicide? I want to briefly review the evidence that was presented to you over the course of the past week. Captain Bake. He assisted with the initial search warrant that was conducted at the Wood Road residence in the early morning hours of June 25th. He also participated in further searches of the property in October, and he put together a timeline of law enforcement activity in the case that was submitted as an exhibit. But he did not provide any testimony regarding the intent element of count one. This was the law enforcement activities Rasch investigation timeline that he put together for you. Next, we had Diana Free. This was Crystal's stepmother. She provided a lot of information, background information regarding Crystal and the family. She testified that Crystal had a learning disability, that she had never held a full-time job, and prior to receiving disability income, she had been supported by her parents. She last saw her on June 6th, and when she returned from a trip on June 23rd, Diana Free was the person who called the police to report her missing. In her words, she thought Zachariah would be the last person Crystal would be spending time with. She was unaware that Crystal was trying to find a new lawyer, and she was unaware that she had signed up for that carrying a concealed weapon permit class. She also did not provide any testimony regarding the intent element of count one. Heather Doherty was next. She was the foster parent for the Rasch children who has now adopted them. She testified that Crystal was lower functioning and needed extra guidance in many aspects of her life. She talked about Crystal's supervised visits and that Crystal had canceled her visit on June 10th because she had been told that Crystal had strep throat and did not want to come and potentially get the kids sick. She mentioned that Crystal skipped one of her children's kindergarten graduation ceremony, and she was also unaware that Crystal was hanging out with Zachariah. She also did not provide any testimony regarding the intent element of count one. Robin Reels was next, Crystal's friend for 24 years, who said that they spoke nearly every day, either by texts or by phone calls. Crystal told her on May 24th that she was going to the Dells with friends, but it didn't say that it was with Zachariah. Robin testified that she believed that Crystal had stopped seeing him well over a year ago. She also did not provide any testimony regarding count one. We next had Kitty Gordon, who was a senior social worker with Dodge County Human Services. She was assigned to the cases involving the Rasch children and the TPR matter that was pending. She provided services to Crystal. She made it clear to Crystal that the Dohertys were excellent foster parents and that she was recommending her rights be terminated and that the Dohertys go through with the adoption of those 4 children. She told Crystal that she would be able to maintain a relationship with those children of some sort. She testified that Crystal refused to engage in mental health therapy, that she was unable to finish the parenting classes that were ordered because they were too hard for her. She largely had supervised visits, and that she was also unaware that Crystal was hanging out with Zachariah. And she also did not provide any testimony regarding count one. None. Next, we had Deputy Kukan. He was the first law enforcement officer that was involved in this case. He spoke with Diana, with Zachariah, and with Robin. He also did not provide any testimony regarding the intent element of count 1. Next, we had Lieutenant Taylor Niels. He's the head of the Detective Bureau with the Dodge County Sheriff's Office. He primarily testified about the bank records of the transactions using Crystal's debit card after June 11th. He also testified to the videos that were collected from the Culvers and the Goodwill in Oconomowoc. He finally testified about some of the search warrant photos from the Wood Road search that occurred at the end of June. But he also did not provide any testimony regarding intent. He did provide through his testimony the videos from the Culvers and the Goodwill. And I'd like to play those for you now. Forward it to about 35 seconds. You can see in the video that Mr. Rasch is paying for the transaction with his own money, with his card. He then takes the number for their food order. The next video I'd like you to watch is that video that you've seen a portion of previously from the Oconomowoc Goodwill. And we'll just watch the first couple of minutes of this video. You see the Rasches leaving and approaching the silver Mitsubishi right at this moment. This is the portion of the video where he's acting as a shield, so she's changing her top in the parking lot, blocking other people's view of her topless essentially in the parking lot. you'll be able to see that when that rear door closes, that Mr. Rasch then goes to the front passenger door and opens the door for his wife. And that's occurring now. He then travels behind the vehicle and then enters the driver's seat. The next witness that we had was Attorney David Lang. As District Attorney Will mentioned in her remarks, this was Crystal's lawyer for all three of her cases, for the TPR, for the divorce case, and also for that car accident case, the personal injury. He testified that she was no longer going to be able to afford the home that she lived in for a decade, and that she would be downsizing into a one-bedroom subsidized apartment. It was his testimony that she never missed a visit with her children, and that she was looking forward to moving on in her life post-divorce. But he was unaware that while she was communicating with him, she was also looking to replace him. He provided no testimony regarding the intent element of count one. Next, we have Detective Sergeant Bradley Conkle. He primarily testified about the flock images in this case, but he did not provide any testimony regarding count one. This flock image is the image that was shown to you all during the trial that showed what everybody suspects to be Crystal Rasch sitting in the front passenger seat of Mr. Rasch's vehicle on Friday, May 31st. So this occurred about 12 days before her death on June 11th. They were also able to obtain additional flock images from Saturday, June 8th, as they traveled up to the property in Adams County to spend the next 3 nights at that location, Saturday, Sunday, and Monday. On Tuesday, June 11th, these are the images that they obtained of the Rasch vehicle in very close proximity to those 2 law firms that were the subject of those searches on his cell phone. And we see the times, June 11th at 1:42. The next witness that we had was Detective Casey Young, who primarily testified to the evidence that was collected from a search of Zachariah's phone, as well as other search warrant photos. The Taurus handgun that was recovered from the dresser in his bedroom was in plain sight. This is what the bedroom looked like at that bedroom on Wood Road. That was Zachariah's bedroom. And this was a picture of the handgun laying plain as day out in the open on the dresser by the TV. Detective Young also provided testimony about the Google web search history that you've heard so much about. The next witness was Detective Kelsey Becker. He drafted the preservation request for Facebook and the search warrants for 4 accounts and testified about the gun, the CCW class, and the holster, but did not provide any testimony regarding the intent element of count 1. I feel like you can sense a theme that's occurring here. Detective Rolfs, next witness, testified primarily about the scene and the excavation photos at Wood Road, the search of Crystal's bedroom, her medications. He did not provide any testimony regarding count 1. This was the pill organizer for her medications that we've talked about at some length, which show that the pills for Thursday, Friday, and Saturday in the AM are gone, which makes sense with the time that she left her residence on Main Street in the village of Kleinman. We know that she left on Saturday morning, but none of the other pills were taken for her multi-day trip up to Adams County. Judge, if you could lower the lights so they can read this one, please. This was the calendar, the wall calendar that was in her bedroom that there was testimony about also. If you need to have a closer look at this, obviously some of these exhibits will be going back to the jury room, but you can see on June 11th, the day that they traveled to Milwaukee, she had an appointment scheduled for an MRI on that particular date that she also did not attend. Next, we had Detective Michael Lake. He testified regarding the surveillance videos and photos of all the various transactions made with Crystal's card, the history of the gun purchase, and the pictures of the recovered Mitsubishi. He also did not provide any testimony regarding intent, regarding the homicide. This is essentially the form from the government that tracks gun sales. And you could see in the middle of the form that this gun was purchased on February 20th, 2024 from Fleet Farm. And this is the purchase receipt, although the receipt at the top has a July date, but that was because that was when the receipt was reprinted. The gun itself, though, was purchased on February 20th. He testified at great length about all of the transaction surveillance, videos, photos, all the information that you had heard about previously through the bank records and the other means. The next witness was senior forensic scientist Trevor Nallad from the Wisconsin State Crime Lab. He testified largely about the processing of the 3 vehicles that were owned by Zachariah. We had the 2002 Dodge Ram truck, we had the 2005 red Chevy Cobalt, and then obviously we had the 2023 silver Mitsubishi, the primary vehicle of interest. From his testimony, it was very clear that whatever happened with Crystal happened in that front passenger seat of the silver Mitsubishi. And based on the blood staining that occurred, the seat belt, he testified, was engaged, being used at the time that whatever incident occurred to her. Based on the blood staining that was visible, that was his testimony. The seatbelt was on, and it was on her body when the gun went off. But obviously, he could not testify as to what caused or who caused that gun to be fired. So he also had no testimony regarding the intent element of count 1. Next, we had a forensic dentist, Dr. Legro, who identified the tooth from the burn area as being Crystal's, but obviously was not able to indicate how or why she passed away. Next was from Bodie Technology, DNA analyst Benetta George. This was the woman who testified via Zoom. She testified that the bone sample that was provided to her through the process that they utilized at their laboratory returned back a positive DNA test result as being a bone from Crystal Rasch. She also obviously could not provide any testimony regarding how she passed away. Next, we had senior DNA analyst from the Wisconsin State Crime Lab, Kimberly Wroblewski. She testified regarding what items were submitted to the crime lab and which items she subsequently tested and what those results were. She provided testimony that the trigger guard, and the handle of the gun were not tested, and she said in her own words that it was due to the case circumstances. We now know that the case circumstances were something that was relayed to her by Detective Contney. Instead of thoroughly testing the gun, they chose instead to test all of these random items for the presence of Crystal's blood. We all know that the blood on those items would have been Crystal's just based upon the other very obvious evidence in the case. She obviously didn't have any testimony to provide regarding the intent element of count one. And instead of testing the gun in multiple locations, they decided to test the Hoover, the vacuum, in 3 different spots. They decided to test the handle of a bottle of detergent. They decided to test a vape pen. They decided to test all of these items that held so little evidentiary value instead of testing the instrument that caused the death of the person in this case. Next, we have from MOCIC, the acronym, the Middle States Crime Information Center, the analytical supervisor, Matthew Anderson. I believe he went by Tyler, but Matthew was his first name. He testified about the data mapping of cellular phone data records that he was provided with from the Dodge County Sheriff's Office. All of the provided testimony that he gave was only from June 11th to June 25th. He testified that he had data from earlier dates, but he was only told to analyze data for presenting at trial here, data from June 11th forward. He admitted that it would have only taken seconds for the software program that they utilize to ingest the data for those earlier dates, and it wouldn't have been a difficult thing for that information to have been presented to you as the jurors here. He obviously doesn't have information about what happened to Crystal. I want to play just one video for you. This was the video from June 11th that showed all of their travel that day from the 2 phones that were connecting, both Crystal's and Zachariah's phone. Their phone is moving down from Adams County now, south and now east to Oconomowoc, where it stays there for about an hour at the Goodwill and the Culvers. And now it's moving back down to Greenfield, near where those 2 law offices were. Stays in that vicinity for about half an hour. And now the vehicle is making its way back up to the residence on Wood Road. And we know from this video that we saw previously, the vehicle returned at approximately 3:30 p.m. and did not move again until about 10:30 that same evening, when Zachariah went and withdrew money later that evening up in Juneau. Instead of playing videos of Mr. Rasch traveling to Menards and other stores, wouldn't you have been more interested in seeing what the traffic patterns were for Crystal and Zachariah in the week or the weeks leading up to June 11th before her death? Instead, they played all of these videos from essentially June 25th backwards to June 11th that really had no consequential significance to this case, and they played them in reverse order for some reason. Next, we had forensic anthropologist Dr. Jordan Karsten. He testified about the identification of all the various bones that were found on the Rasch property through the various searches that were done there. I believe there were at least 3 separate searches that were done. He was a very informative person. It was very educational. He gave us, quite an anatomy lesson, but he really was not able to provide any information, once again, regarding the intent element of this homicide charge. The last witness for the state was Detective Justin Contney, the case officer for this matter. Testified, to quite a few different items, cleaning up various topics or unanswered questions, but primarily he testified about the very long 11-hour interrogation that he and Detective Rolfs had with Zachariah. Even after the 11 hours, we saw all the lies. We saw all of the, non-responsive answers to many of the questions. But throughout that process, Zachariah never said, "I killed Crystal Rasch." We know that much. And then the final witness, obviously, is Zachariah himself. He testified this morning, so it should be very fresh to you. And his testimony regarding what happened inside of the Mitsubishi is the only evidence that you've heard on that matter. He chose to testify this morning. He didn't have to. And he also provided answers as to why he made some of those Google searches. He talked at length about the days preceding Crystal's death and what they were doing. And he specifically talked about how this death occurred on June 11th. Admittedly, after her passing, he engaged in a series of terrible decisions. The disposal of her body, burning it, using her debit card, subsequently lying to the police. But what he did after the fact of her passing is not evidence of how she passed away. There was a comment that was made by DA Will in her remarks that, he lied constantly and consistently to the detectives during that interrogation. If he had told them what he told you this morning, do you think that the result in their minds would have been any different? No. They still would have arrested him for her homicide. Whether he told them the story, the truth of what occurred that he told you today, or whether he continued to deny knowing where she was, the result was going to be the same in their minds. Remember, Detective Contney said we all know what 2 + 2 equals. The decisions at that point in time, not only did they have the information, because as the DA Will said, they don't go into these interrogations not knowing what answers they want. They know precisely what answers they want. And he was not going to provide the answer that they wanted, and therefore he was going to be deemed a liar. He testified that he was going to be scared, that he was going to be blamed for her death. And given who he is and the history, this was a legitimate concern. So those were all the witnesses that you heard from. So what are we left with now? Let's start with what we know about Crystal. We know that she was leading a double life of sorts. While she complained to others about Zachariah, she was secretly continuing their relationship. Everyone who testified in this trial that knew her, that was a civilian witness, nobody knew that she was still seeing Zachariah. And these were all supposedly the people who knew her best. Her stepmom, her best friend, her caseworker, the foster mother of her children, and her lawyer, who says that she would contact him multiple times a week. She was secretive when she was meeting with Zachariah. She hung out, we know, with him for days at a time. We know from testimony that she had some cognitive issues. She was described as being low functioning and needing assistance. We know that she was receiving disability income. There was really an attempt by those civilian witnesses to portray her as somebody who was very optimistic and looking forward to the future. I think there is a natural tendency that when somebody passes away, that we want to look back on their life and see things in a light that's oftentimes better than things might actually have been. I think it's easier that way to think that there were no signs that she was struggling, because then there's nothing that they could have done in hindsight to prevent her death. But we know that she was facing some significant and serious, difficult life circumstances. She was about to lose her home of a decade and downsize into that subsidized one-bedroom apartment. She was going to be losing her parental rights in the very imminent future to all 4 of her children. Even the caseworker that she was so close with was going to recommend her rights be terminated and that these kids be adopted by the Dohertys. And third, she was going to be getting divorced. Any one of those things individually would have been a lot to deal with, even for a person who was of ordinary functioning, who was in a good mental space. These are incredible, difficult life events. And many people have engaged in self-harm when faced with even one of those 3 monumental events that Crystal was facing. We know that she wasn't seeing her mental health providers and that she likely left her medication behind when she went up to Adams County that weekend. We know she missed her child's kindergarten graduation. Odds are likely that the strep throat excuse was just that, an excuse. We know that she lied to her mom on June 10th when she said that she did in fact visit her kids. Detective Contney's report said in fact she did not. We know that she skipped her MRI appointment, the following day when she went to Milwaukee. We know that she was in Milwaukee trying to find new lawyers as perhaps a desperate Hail Mary. Maybe a new lawyer can help save this case and maybe my rights to my children won't be terminated. But when she went to Milwaukee, she was turned away because in their lack of planning, they didn't make an appointment. And maybe as ordinary people, we realize that you can't just walk into an attorney's office just off the street and expect to have, a consultation on the spot. Is it reasonable that somebody in her condition, facing her challenges, and in a desperate moment, might try to harm herself? It is. It is reasonable. It would not be surprising at all when you take a step back and you look at the realities of her life. She was a person who in ordinary times required substantial assistance to deal with ordinary affairs of life. And these were not ordinary times for Crystal. Now let's talk about Zachariah. You've had an opportunity to observe him this past week. Out of most people in the courtroom, you're the closest to him. You've seen his demeanor. You've seen his lack of communication, quite honestly. I don't think I've ever had a client as quiet as him during the course of a trial. You listened to his testimony this morning, and you saw hours of his interrogation video. I don't think anybody would describe him, and this is not an insult to him, but I don't think anybody would describe him as a particularly sophisticated or cunning person. He has an 11th grade education, and he has spent his adult life largely working simple factory assembly jobs. As you have observed him this week, you may think of him as being somewhat of an odd person, strange even perhaps. But what I think is largely true about Zachariah is that he has spent the majority of his life living on the edge of society in ways that are both literal and also figurative. You saw pictures of the house that he resided in. We can all agree that these are not normal circumstances. That house is secluded and it's isolated. He's a man of very few words and few friends. We know through the testimony of a variety of witnesses that many people in her family, Crystal's family, and her friends disliked him, even prior to June 2024. That much was clear. It's understandable why a person like Zachariah, when placed in the position that he was, with her dead in his vehicle, would believe that nobody would believe him if he told them that she did this to herself. Does it excuse any of the actions that he engaged in after she died? No, it doesn't. It doesn't excuse the fact that he disposed of her remains in the way that he did, or that he utilized her debit card, or that he lied to law enforcement. But if you were Zachariah, it's understandable to know why he acted and he did the things that he did in the days and the weeks after she passed away. You heard a lot about all of the things that he did after her death, but none of his attempts to dispose of her remains is proof of intent that he actually killed her. You heard Mr. Rasch testify this morning, Zachariah. He admitted to the numerous lies that he told law enforcement, and he also admitted to disposing of Crystal's remains. You could choose to believe what he said today in whole, in part, or not at all. It's your job to judge the credibility of any witness. But there is objective evidence in the record as to what happened on June 11th. That's the reason why I wanted you to see those videos one last time in my closing. So let's consider the last verifiable actions that were taken by Zachariah. They woke up very early in the morning in Adams County. They traveled to Oconomowoc. You saw the video at Culver's. They're standing in very close proximity to one another, standing as couples often do when they're ordering food at a counter. You saw him take out his wallet and pay for the drinks and the meals for him and his wife. You saw then the next video of him at the Goodwill when they were exiting the store. He shielded her from public view as she was changing her clothing in the parking lot from the sweatshirt to the shirt that she bought there at the Goodwill. After that, he then goes to the front passenger door and opens the door for his wife to sit in the vehicle. I can't remember the last time I opened the passenger door of the car for my own wife. But you saw him do it. And maybe it's a good reminder that maybe we should do that more often. Then what we know unequivocally from the flock pictures that I showed you. And keep in mind, we start this day in Adams County, a couple hours away from Greenfield, Milwaukee suburb, Wisconsin. That he then drove her to Milwaukee from Oconomowoc, which took another hour or so, in an attempt to find new lawyers to fight her case that at that point she was still interested in fighting. And we know that she was met there with disappointment, that she couldn't meet with the lawyer at that moment in time. And we know that he returned back to his residence on Wood Road by 3:30 that afternoon. Those flock images of when they're in Greenfield are approximately 1:42 to 1:45. The state wants you to believe that despite what you saw earlier in that day, chivalrous behavior by Mr. Rasch towards his wife, that somehow something shifted so dramatically in that hour and 45-minute drive back from Greenfield that this individual who's on video buying meals, shielding her, opening doors for her, and driving her a considerable distance in an effort to, help her with her case, somehow then turned into a murderer. Something just flipped, a switch, and instead of the gentle, kind person that you see on those videos at the beginning of June 11th, that by early afternoon, he has then decided that he's going to kill her. They presented no evidence as to why he would do such a thing. There was no evidence presented in this case about progressive, increasing hostility in the days and the weeks leading up to June 11th. Nothing. One of the questions that Attorney Zahawi asked you in opening, and I referred to it at the beginning of this, was, would you have lingering questions, questions unanswered, when all the evidence was submitted in this case? DA Will, on several occasions in her closing argument, said this was a premeditated, purposeful homicide. If that was the case, why buy a gun from a licensed dealer? If his intent when getting the gun was that he was going to use it to murder his wife, why would you buy it from a licensed firearms dealer? Why would you sign up for a carrying concealed weapon permit? Another entry into a government database saying that you had a handgun now. If the gun was in fact the murder weapon, why was it left in his room in plain sight when we know that the following day after Deputy Kukan came to the house that he took the Mitsubishi up to Adams County? Why wouldn't he stash it in the 80 acres of woods or in one of the numerous trailers on that property? I didn't know whether the state's theory was, was this premeditated or was this an impulsive act? DA Will has told you several times this was premeditated. This was premeditated, no doubt in her mind about it. If it was a premeditated act, why would he do it in the car? Why would you do it in a place that would be so difficult to clean? And if you were going to do it in a car, why would you do it in your new car? He had a 22-year-old truck and a 19-year-old Ford Cobalt, but we're supposed to, expect or understand that he would do this in his 1-year-old car that he's still making payments on? It doesn't make any sense. Other questions. If this was premeditated, they were at the rural Adams County wooded property for days. Why wouldn't he do it there? Why would he go to Milwaukee? Why would he take her there? Why would he help her try to find a new lawyer? Why would he buy her a meal? Why would he do any of these things? And in terms of the investigation in this case, why didn't law enforcement investigate her mental health? Why didn't she take her medication with her? What would happen if she suddenly stopped taking her medication? Why didn't they interview more of her family and friends? Why didn't they interview more civilian witnesses who knew her personally and may have had insight as to what was happening in her life in the days and the weeks leading up to this incident? And why not test the trigger and the trigger guard and the handle of this firearm? It is arguably the single greatest piece of evidence that they had, and they neglected to do it. Why not investigate what was happening before June 11th? Why didn't you see what her travel patterns were, how often she was hanging out with Zachariah? You haven't been presented with any of that information. And ultimately, what reason did he have to do it? Manner of death. Natural causes. We obviously can eliminate natural causes, right? It's pretty obvious. Let me just backtrack one sentence. The third and final question that was posed to you during the opening statements was, would the state be able to prove beyond a reasonable doubt that this was not an accident or a suicide? So then we have these 5 manners of death. Natural causes, undetermined, accident, suicide. If the state is asking you to find Zachariah guilty with proof beyond a reasonable doubt of homicide, you have to eliminate with proof beyond a reasonable doubt that this was not an accident, proof with beyond a reasonable doubt that this was not a suicide also. You have to rule out those options first before you can decide whether or not this was an intentional act. This is part of the instruction for burden of proof and presumption of innocence. It's the reasonable hypothesis. If you can reconcile the evidence upon any reasonable hypothesis consistent with Zachariah's innocence, you must do so and return a verdict of not guilty. You must do it. The law requires it. A reasonable hypothesis in this case, based upon the evidence and the lack of evidence that was provided to you all, is that Crystal Rasch shot herself. Coupled with the shocking lack of evidence regarding intent, we respectfully ask you to render a verdict of not guilty on the homicide charge. Thank you for your time.
Very well.
Is that one so juice, or should I try?